All right, everybody, we want to welcome you to Pastor's Point of View. Today is June the 19th, 2020. My name is Dr. Andy Woods. I'm back with my friend, colleague, fellow elder, associate professor. Well, you want to be
whatever.
You can be a professor if you want.
Thank you.
Pastor, professor, whatever you want to
Add
be.
that down.
Dr. Jim McGowan. And we're back with you with another show of Pastor's Point of View. We didn't meet last week because we were tired.
Yeah. We gave it all the week before.
Yeah, I think we kind of outlined what was going to happen in the subsequent 2 weeks.
Yes.
And so everything we said has happened.
That's true.
That's true. It's just more of the same.
More of the same.
And so we're actually switching subjects today, Brother Jim. And kind of our biblical entry point to all of this is Daniel 7.
Mm-hmm.
Verse 19, verse 23, and verse 25 talks about a coming beast.
Yeah.
That would be the New World Order.
Mm-hmm.
That will crush and trample down everything. In fact, it says there it's going to devour the whole earth.
Right.
And from that big beast, fourth beast, is coming a little horn
Mm-hmm.
who will intend to make alterations in times and in law.
Right.
So prophetically, we know that what is on the horizon is the coming New World Order. Standing in the way of the New World Order is a free and independent, prosperous United States of America, which,
Yes.
by the way, as far as I can tell, is not mentioned in the pages of Bible prophecy.
Mm-hmm. Yeah.
So something's got to give.
True.
And we believe that many of the things that we're seeing today, in fact, things that have developed in the last several weeks, are preparatory to get America out of the way.
Yeah.
So the New World Order can come.
Yeah.
There have actually been three things. The third one is what we're going to talk about today. All of these have not arisen as a result of the American people.
Mm-hmm.
All of these things are being forced on the American people, including what we're going to be dealing with today. The first is the pandemic, COVID-19.
Mm-hmm.
The second one is these protests that have gone on all over the country.
Right.
They want you to believe this is just a kind of an organic grassroots uprising against the terrible death of George Floyd.
Mm-hmm.
But pallets of bricks appearing at just the right time leads you in the direction that this is not pandemonium, it's plandemonium.
Yes, sir.
And our last two PPOVs, I think we're on number 127 today, but numbers 125 and 126 got into that second issue. And today, Brother Jim, as if all of that weren't enough, we've got now a third thing coming against the United States of America, and that's basically a wayward, out of control Supreme Court.
Yes, sir.
Now, the other issues are going to go away, I believe. Eventually, the rioting is going to stop.
Sure.
Eventually, COVID-19 is going to lose its teeth and America will get back to work.
Yeah.
But this third issue that we're dealing with here is not going to go away.
No, it's
in other words, Donald Trump, whether he gets a second term or not, let's pretend he does. I hope he does.
Mm-hmm.
He'll be gone one of these days.
Mm-hmm.
And this issue that we're talking about here will continue on.
That's right.
And so of the three issues, this right here, I believe, is the most serious, but most conservative organizations are treating the other two as if they're the most serious.
Yeah.
And this one is the most serious because it has to do with the redefinition of sexuality. Not by a vote from the American people, but by the federal judiciary.
Mm-hmm.
And when you get into books like Edward Gibbon's The Rise and Fall of the Roman Empire, what you learn is the normalcy of homosexuality is what eventually caused the destruction of Rome.
Yeah.
And so that's why this issue is so significant. So I don't know if people felt the tremor, but on Monday, June the 15th, Monday of this week, we're videotaping or recording on a Friday, the ground literally moved.
It did.
Did you feel the ground moving?
I didn't feel it, but boy, I'm feeling it now.
Yeah, most people were unaware of what happened.
Yeah.
And the severity of what happened related to the Supreme Court we're going to be talking about today. Now, the Supreme Court came out with another decision, I think it was yesterday, the DACA decision, and that relates to the Dreamers, and it relates to Obama's executive amnesty. And so everybody agrees that what the Obama administration did in terms of executive amnesty, granting to a whole bunch of people that aren't here lawfully the right to stay in the country, that was illegal.
Right.
And so what the Trump administration did is try to erase that or reverse that. And so the Supreme Court yesterday in a case held that the Trump administration's effort to erase the Obama administration's illegal activity is in and of itself illegal. So it's illegal to erase illegality.
Wow.
And as bad as that decision is, that can be fixed if proper procedural guidelines are followed.
Yeah.
The decision on Monday cannot be fixed.
Yeah.
And so that's why what we're talking about here is such a big deal. In other words, I'm not ashamed or afraid to say this. We as Christians lost the culture war.
I think so.
On Monday, given the significance of this decision. The decision that came out on Monday, I believe, is the most significant decision that has come out since Roe versus Wade.
Yes. Yes.
You know, that infamous decision that came out in the early 70s, essentially legalizing abortion.
Yeah.
There hasn't been a more serious decision that's come out subsequent to that other than what we just got hit with on Monday. And most people don't even realize it.
Right. Not hearing about it on the news.
No. And most mainstream conservative organizations are not giving this issue the attention that it deserves. So we're going to be going into depth today on this. So if you look at our third slide here, this is the ground we have to cover today. 7 things. So let's start with here number 1. And I have listed here under number 1, other cases denied. So when the Supreme Court made the decision it made Monday in a case called Bostock versus Clayton County, 2020, they made a radical decision, which we're going to talk about, but in the process they denied the opportunity to make constitutional rulings.
Yeah.
So they denied what is called writs of certiorari, and in law you have a lot of Latin terms. And so a writ of certiorari is basically, when you deny a writ of certiorari, the court is basically saying, I'm not going to hear this particular controversy. So what did it deny? We have an article here from somebody that I would turn people on to in terms of really understanding this issue, Daniel Horowitz of conservativereview.com. And he writes an article June the 15th, 2020, conservatives get massacred by fake conservative Supreme Court of the United States. And just to make us aware of what the court turned down in terms of having opportunities to rule on things that would actually have something to do with the Constitution, and instead take the opportunity to rule on something that has zero to do with the Constitution. What did the Supreme Court turn down first? It turned down 3 cases. Do you mind reading just that opening paragraph?
All right. Within 35 minutes today at 10 a.m. Eastern.
That would be Monday when this was written.
Right. What some thought was the most conservative Supreme Court of all time concocted a fundamental right to transgenderism in the context of labor law, erased the Second Amendment, and interfered with a state death penalty case, but declined to interfere with a California law that criminalizes law enforcement cooperation with federal immigration agents. Taken in totality, the, quote, conservative legal movement, which has promoted the idea of, quote, appointing better judges, rather than fighting the entire concept of judicial supremacism, has failed miserably. This was its Waterloo. Here is a brief summary of 4 very important decisions and orders issued by the court today.
All right, number 1, they denied writ of certiorari for the fact that state governments are denying people's Second Amendment rights.
Correct.
I mean, the last time I checked, the Second Amendment's in the Constitution. We're not going to rule on that.
Yep.
Number 2, they denied writ of certiorari. Let's see, it says, in U.S. versus California, the Supreme Court denied the position from the Department of Justice to overturn the Ninth Circuit's ruling upholding California's sanctuary city or sanctuary law. So you got a conflict between what California is doing and what the federal government is doing in the area of what are called sanctuary cities and sanctuary laws. Not going to rule on that.
Right.
We are going to interject ourselves in a capital punishment case. We'll get involved in that, even though capital punishment is actually part of the Constitution because it says the state can take life as long as due process is afforded.
Yeah.
So we're going to take liberal positions on all these other things, but here's what we are going to get involved in. In a 6-3 opinion written by Justice Gorsuch, the court ruled that Title VII of the Civil Rights Act, which passed in 1964, before anybody could fathom transgenderism, applies to transgenderism and sexual orientation.
That's the biggie.
That's the biggie. So, guns, no, we won't rule on that. Borders, won't rule on that. Capital punishment, we want to interfere in that, even though that's in the Constitution. But here's what we're really going to go after. We're going to rewrite the Civil Rights Act of 1964 so that it contains sexual orientation and transgenderism. So that becomes striking in terms of what they decided to act on and what they decided to reject.
Right.
And so that's why this issue becomes huge. Their job is to protect the Constitution, and when they have opportunity to do that, they don't do it. Their job is not to rewrite statutes, and when they have the opportunity to do that in the name of political correctness, that's a cause they decide to take on.
But I know we're going to talk more about this in a minute, but again, it comes back to what we've talked about before. All of a sudden, the Supreme Court is making law.
Absolutely. And can you
That's
read that?
a problem.
That's a big problem. Can you read that last paragraph there, just in front of the facts?
Taken together, these decisions, the ones we've just referred to, show the court believes there is an inalienable right to transgenderism and illegal immigration, but not to the Second Amendment. The court believes it can tamper with every state criminal and capital conviction on ever-evolving novel grounds, but it somehow believes a state can criminalize foundational federal immigration powers.
So it has no interest, our Supreme Court, in protecting the rights that exist in the Constitution. And it has every interest in creating what are called faux or false rights.
Exactly, yes.
So that's what happened on Monday.
That's right.
So let's talk about this particular case and what were the facts that led up to this particular case. We're looking here at number 2, facts. And we have kind of a summary from LifeSite News, Calvin Freiberger. And by the way, a lot of these articles that I'm quoting, we're going to keep kind of cycling back to them. So if you say, well, you already cited that article, well, that's because there's a lot in each article.
Right.
And we can't give you the whole kit and caboodle, out of the gate. So we're going to be recycling back to a lot of these articles. But this particular article is called "The U.S. Supreme Court Votes 6-3 to redefine sex and write transgenderism into a 1964 law." And you might be saying, well, why is this a big deal? We're going to explain all that. But right now, we're just trying to lay the foundation. Do you mind reading that first paragraph there?
All right. The case consolidated several suits into one, including that of a Christian funeral home that fired a male employee who insisted on dressing as a woman on the job, a skydiving instructor who was fired after informing a customer he was gay, and a county child welfare services coordinator who was fired after his employer learned he was gay.
So we got 3 cases that the court consolidated.
Mhm.
They all have the same fact pattern.
Mhm.
So the court decided to take on this issue all at once. The first thing you have is this person, Amy Stevens. Now, Brother Jim, when you're grieving over a loved one and you're going to a funeral home or that kind of thing, do you really want to deal with, as a customer, a man that suddenly decides he's a woman and shows up in a dress as an employee of that funeral home?
That would be a problem. Yeah.
I mean, I would think it would be reasonable if the funeral owner told such a person that, I'm sorry, you don't work here anymore.
Mhm.
I mean, you're going to alienate customers
Right.
by doing this kind
Right.
of thing. And that's what, essentially happened is you have somebody who was hired, I guess, as an embalmer. It says Amy Stevens lost her job as a funeral director in the Detroit area after she revealed to her boss that she had struggled with gender most of her life and at long last decided to become the person that my mind already is. Stevens told the funeral home owner Thomas Ross that following a vacation she would report to work wearing a conservative suit or dress that Ross required for women who worked at his 3 funeral homes. And so Ross, the owner, who by the way is a Christian,
Mhm.
and has Matthew chapter 6 verse 33 on his promotional literature.
Mhm.
And I think he's, seek ye first the kingdom of heaven or kingdom of God,
Mhm.
and all these things will be added to you.
Mhm.
And I think he's a member of the board of the local Salvation Army, something to that extent. He just decided that this was not good for his business
Mhm.
to have
Mhm.
someone, that's one gender decide they want to be another gender and show up in a men's outfit or a women's outfit or what have you.
Yeah.
So sorry, you don't work here anymore.
Right.
The second case dealt with Donald Zarda, and this comes out of New York, and he was working as a skydiving instructor.
Mhm.
Now, I've never done any skydiving myself, but I think it involves a situation where the instructor is behind you, and the two of you, are you not thrown out of the airplane together?
Yep.
And so the one behind you is giving the customer a great big bear hug, I
Right.
guess, all the way down.
Yeah.
And this guy all of a sudden comes out and starts disclosing his homosexuality.
Mhm.
Now, wouldn't that be kind of awkward for customers?
Well, it would be quite strange, Yeah.
And so the owner said, sorry, you don't work here anymore.
Mhm.
And the third case involved Gerald Bostock. And he disclosed his sexual orientation to his owner, his homosexuality, transgenderism, etc. And this particular owner got rid of him because he had apparently mismanaged funds.
Mhm.
And of course, he claimed, well, you didn't get rid of me because I mismanaged
Right.
funds. You got rid of me because of my disclosure to you of my sexual orientation. So these are all 3 similar fact patterns that the court consolidated and decided to hear. And this particular case is called Bostock versus Clayton County, 2020. So, number 3, what was the ruling of the court in this particular case? Back to the Daniel Horowitz article from Conservative Review, he kind of sums up the holding, what the court held here.
All right, and here's what it says. By far the most devastatingly consequential case of the day was the transgender, quote, discrimination case, Bostock versus Clayton County 2020. Writing for the majority, Gorsuch claims that when the statute uses the term, quote, sex, it can apply to sexual orientation and gender identity. Quoting, an employer who fires an individual merely for being gay or transgender violates Title VII of the Civil Rights Act of 1964, concluded Gorsuch. He was joined by the 4 Democrat appointees as well as Chief Justice Roberts. Gender and sex are indeed not separate things.
All right, so who wrote this decision? Gorsuch.
Mm-hmm.
Now, who is Neil Gorsuch? Neil Gorsuch is Donald Trump's first
Yep.
pick when he got an opportunity to fill a vacancy on the United States Supreme Court. Someone that everybody told us was a conservative.
We did a program about him.
Well, actually, we did a program about Kavanaugh.
Or Kavanaugh. Okay.
Gorsuch is different, but it's the same animal.
Similar idea.
Similar idea. Everybody told us he was a conservative. Everybody told us that he was in the mold of Anthony Scalia, one of the great stalwarts of original intent on the United States Supreme Court. And it's Gorsuch that comes out with this decision that looks at the Civil Rights Act of 1964, which protects people from discrimination on the basis of an immutable characteristic that they can't change about themselves.
Exactly.
Like national origin, race, religion, gender. And Gorsuch waves a magic wand and reads transgenderism, sexual orientation, and gender fluidity from his position in 2020 back into a 1964 statute.
Yeah.
And claims he's doing it as a conservative.
Yeah.
So, as one of the talk show hosts said, this decision no longer relates to genitalia. Sorry for being crass here. It used to relate to discrimination based on what genitalia you have. Now, it's wrong under employment law to discriminate against people based on how they behave with their genitalia, based on how they use their genitalia. So that's a huge change in the legal system, would you not say?
Yeah, that's true.
And who voted for this particular ruling? You've got your 4 liberals that will always be liberals.
Right.
They'll always vote left.
Yep.
Breyer, Ginsburg. Now, Ginsburg is a former employee on the payroll of the American Civil Liberties Union, one of the most radical leftist groups imaginable. Ginsburg is the one that didn't like, she has involved in a decision going way back, the age of consent. So we've got to lower the age in which children can have sex. So Breyer, Ginsburg, Kagan, and Sotomayor, they voted in favor of rewriting the statute. No big surprise there, but here is the big surprise. This decision wouldn't have come into existence without Republican support.
That's
and
right.
You've got 2 Republican Benedict Arnolds turncoats
That's right.
who decided to vote with the liberal voting bloc.
That's right.
Those are, number 1, Roberts, a Bush appointee. They all told us he was a conservative when he got appointed.
Yep.
By the way, it was Roberts that upheld Obamacare.
Yep.
And gave the folks arguing the case the idea that maybe this is a tax. And consequently, the whole thing was upheld. Universal health care. So Roberts sides here with this particular case, and then the guy that surprised everybody is Neil Gorsuch. So you've got 2 Republicans, Gorsuch and Roberts, siding with the liberal bloc, a 6-3 vote. And so that's why we have the ruling that we have. You've got 3 that are very good in terms of dissents. They are Thomas, who's probably the best guy we have up there.
Boy, that's right.
Alito, who comes out very, very well here with a wonderful dissent he wrote. And then a guy that you mentioned a few moments ago, Brett Kavanaugh, he dissented. But he kind of says, well, I'm very sympathetic to the homosexual cause. But you guys need to get this resolved through the other branch of government, the legislative branch. So he issues what I would call a good dissent, but a very soft dissent.
But he was right.
But he was right.
He was right in saying this is a legal matter, not a judicial matter.
Exactly. So those are the 3 dissenters, the 4 liberals, and the 2 turncoat Republicans. And the villain in this case, as we're going to show, is Neil Gorsuch. So that is basically what the ruling was. They, from the year 2020, reach back into the word sex or gender in the Civil Rights Act of 1964, which had a concrete meaning,
Yes.
and they altered that meaning.
Yes, that's exactly right.
And they didn't get this changed through the legislative branch of government, which is accountable to the people. They got it changed through the judicial branch of government, which is unaccountable to the people, since judges are appointed at the federal level for life.
Well, and let's be honest, back in '64 when they used the term discrimination with regards to sex, as you said, that meant discrimination. The reason that was in there was because women were being discriminated against. There were men and there were women. Women were the ones that were the victims, so they were fixing that problem.
That's right.
Now they've said, oh, no. We need to reinterpret that word, and we're going to expand that definition.
Absolutely.
I know we're going to talk more about that.
Yes, we are.
That's what's going on here.
That's exactly what's happening. So we're just laying the foundation here. We haven't really told people our big problem with this, because this is going to lead to a top-to-bottom realteration of our society, as we're going to demonstrate. But let's move here to number 4. You have now the dissent. Alito writes what I would consider to be brilliant dissent. We have a lot of it quoted here from the Daniel Horowitz article. Do you mind reading that excerpt to us?
Sure thing. But either way, this ruling is absurd beyond belief. Here is the relevant paragraph from Justice Alito's dissent, joined by Thomas. Quoting now, "The court tries to convince readers that it is merely enforcing the terms of the statute, but that is preposterous. Even as understood today, the concept of discrimination because of sex is different from discrimination because of, quote, sexual orientation or, quote, gender identity. And in any event, our duty is to interpret statutory terms, listen carefully, folks, to, quote, mean that what they conveyed to reasonable people at the time they were written, close quote."
In other words, what did sex mean in 1964 according to that statute?
Which we just mentioned,
yes.
Right? So Scalia, Garner, reading the law. The interpretation of legal text 16-2012, emphasis added by us here, I think. If every single living American had been surveyed in 1964, it would have been hard to find any who thought that discrimination because of sex meant discrimination because of sexual orientation, not to mention gender identity, a concept that was essentially unknown at the time. There is not a shred of evidence that any member of Congress interpreted the statutory text that way when Title VII was enacted. The court attempts to pass off its decision as the inevitable product of the textualist school of statutory interpretation, championed by our late colleague, Justice Scalia. But no one should be fooled. The court's opinion is like a pirate ship. It sails under a textualist flag, but what it actually represents is a theory of statutory interpretation that Justice Scalia excoriated, the theory that courts should, quote, update old statutes so that they better reflect the current values of society, close quote. The majority is, quote, usurping the constitutional authority of the other branches, close quote, of government, and has taken the latest congressional bill on this topic and, quote, issued it under the guise of statutory interpretation, close quote. At oral argument, the attorney representing the employees, a prominent professor of constitutional law, was asked if there would be discrimination because of sex if an employer with a blanket policy against hiring gays, lesbians, and transgender individuals implemented that policy without knowing the biological sex of any job applicants. Her candid answer was that this would not be sex discrimination, and she was right.
All right, number 1. Does the word sex protecting women from discrimination in 1964,
Mm-hmm.
would anybody today
Mm-hmm.
confuse that term, gender or sex, with sexual orientation or transgenderism or gender fluidity? No, they wouldn't.
Right.
Let alone in 1964.
Right. Exactly.
Number two, you'll notice here that in his dissent, Alito quotes from, and you read the text, a text written by Scalia entitled Reading the Law, the Interpretation of Legal Texts. I happen to have that one, in my library. It's a very good one. And Scalia himself indicated in that particular text that you evaluate terms in a statute or a law based on what those terms and law meant then when it was passed.
That sounds real familiar, doesn't it?
Well,
that almost sounds like a
unpack-
biblical
Sure.
concept of original intent.
Yeah, literal, grammatical, historical
Isn't that
method of
something? Imagine
interpretation.
that.
So it's interesting that Alito, in his dissent, is using the words of Scalia to refute Gorsuch, and I think that's by design,
Mm-hmm.
because Gorsuch, everybody believes, was a disciple of Scalia.
Mm-hmm.
I mean, in fact, when he was confirmed, everybody just said, and the conservative movement told us, he was going to be just another Scalia.
He missed a few lessons, apparently.
So when, Alito uses Scalia's textbook to refute Gorsuch, he's showing that this man is a wolf in sheep's clothing, is essentially what he's doing here. Beyond that, every single American surveyed in 1964 would not have understood the word sex or gender as used in that statute as somehow a synonym for transgenderism.
Right, right.
Beyond that, every single legislator that passed that law in 1964 would never have confused
That's right.
two terms.
That's exactly right.
And beyond that, a prominent professor of constitutional law during this whole thing was asked if there was discrimination because of sex if an employer with a blanket policy against hiring gays and lesbians and transgender individuals implemented that policy without not knowing the biological sex of job applicants. Her current answer was that this would not be sex discrimination.
Yeah.
And she was right.
Yeah.
And beyond that, what's so interesting about this whole thing is when Gorsuch wrote this, he said, I'm an originalist.
Mm-hmm.
I'm a textualist.
Yeah. Yeah.
No, you're not. I like what Alito says here. The court's opinion is like a pirate ship.
Mm-hmm.
It sails under a textualist flag, but what it actually represents is a theory of statutory interpretation that Scalia would have excoriated, in fact did excoriate, and that's why he's using Scalia's own textbook against this opinion from Gorsuch. And probably the most important thing, and this is where we're going to be spending all of our time, or most of our time, as people will see, is that the majority is usurping the constitutional authority of the other branches of government.
Indeed. That's
and
right.
what I want people to understand, if they don't understand anything else, is that when the Supreme Court does this kind of thing and gets into the business of not interpreting laws but rewriting them,
Mm-hmm.
not interpreting the Constitution but rewriting them, they federalize issues, thereby taking them out of the hands of the people's representatives.
That's right.
So the bottom line, brothers and sisters, is that we are losing the culture war. And the reason we are losing the culture war is not because of us.
Mm-hmm.
It's because issues like abortion, like the removal of Bible reading and prayer in public schools, like this whole issue of civil rights and which direction it should go, is not being decided by you, Mr. and Mrs. America.
That's exactly
It's being
right.
decided by life-tenured, unelected judges. See, this is why you can go to a mega rally. You can put a Make America Great Again hat on. You can go to a rally and scream and yell until you're hoarse. You can go out and vote.
Mm-hmm.
You can get all your friends to vote. And here we are in this country culturally doing the exact same things we were doing decades ago. We're still slaughtering babies around the clock.
Yep.
We're still giving special rights to people, not based so much on an immutable characteristic, but behavior.
Mm-hmm.
And why does this keep happening? It's because the key cultural issues of the day have been taken out of your hands.
That's exactly
and
right.
that's exactly what Alito's dissent is getting at here.
Mm-hmm.
The majority, 6 judges in this case, or justices, is usurping the constitutional authority of the other branches.
That's it.
So that's a little bit about the other cases that were denied, so the court can make a ruling here, the facts of the case, the ruling in the case, and Alito's dissent. And let's talk about, Brother Jim, how what we would call the separation of powers is being turned over on its head.
Mm-hmm.
One of the reasons that we're concerned about so many of the things that are happening with COVID-19 is governors are making executive orders.
Right.
Now, the governor is not supposed to make law.
Right.
He is supposed to enforce existing law.
Mm-hmm.
And when governors get into the business of passing regulations and rules and what shopping malls you could go and how frequently you can be outside and how many people can be in a church and whether you can sing in a church and whether you can have communion in a church, et cetera, et cetera, et cetera. Essentially what is happening is the governor is usurping a legislative function.
Right.
Now, we've covered that issue, have we not?
Yes, we have. Mm-hmm.
That is exactly what's happening here with the Supreme Court. The Supreme Court is usurping a task and a responsibility that should rest with the legislative arm of government. And this is what we would call a separation of powers problem.
Yes.
Now, if you look at our 9th slide here, Brother Jim, you see the sources that our founding fathers quoted when they put together our Constitution. 34% of their original sources, this comes from a study by Donald Lutz. I have the source there at the bottom of the screen. 34% of the quotes come from the Bible. So the Bible was quoted by our founding fathers 4 times more than any other source.
That's amazing.
But the next guy on the list is a guy named Baron Montesquieu. 8% roughly, then William Blackstone, 8%, and John Locke, 3%. Now, what's interesting about Montesquieu, Blackstone, and Locke is those were men steeped in the Bible.
Yes.
So when our founding fathers put together our system of government, when they weren't quoting the Bible, they were quoting men influenced by the Bible.
Yes.
And the second major source that they quoted was this man named Baron Montesquieu. And Baron Montesquieu, it is believed by most people, gave us the concept of separation of powers. Now, where did Baron Montesquieu get this idea of separation of powers? Well, according to Alvin Schmidt's book, Under the Influence, How Christianity Transformed Civilization, he has a number of quotes here from Baron Montesquieu's The Spirit of Laws, where Baron Montesquieu tells us exactly where he got this idea of separation of powers from. He got it from Christianity.
And that's something.
Do you mind reading that quote here as Schmidt is making several references to Montesquieu's original writings?
All right. While many American history books have noted that the 3 branches of government in the United States are derived from Montesquieu's theory, none to my knowledge have ever noted how his argument for 3 branches was influenced by his admiration for Christianity. He saw Christian spiritual ideas as vital to the nation's liberty, quoting, "It is not enough for a religion to establish a doctrine, it must also direct its influence. This the Christian religion performs in the most admirable manner, especially with respect to the doctrines of which we have been speaking. It makes us hope for a state which is the object of our belief, not for a state which we have already experienced or known," close quote. Contrasting governments under Christianity to those under Islam, Confucianism, Hinduism, and Greek paganism, he found those under Christian influence far superior in fostering civic freedom. Quoting, "The Christian religion," he maintained, "is a stranger to mere despotic power. The mildness so frequently recommended in the gospel is incompatible with the despotic rage with which a prince punishes his subjects and exercises himself in cruelty." Close quote. Again, quoting, "We shall see that we owe to Christianity in government a certain political law, and in war a certain law of nations, benefits which nature can sufficiently acknowledge." Close quote. And he defended Christianity by chiding a critic who did not, quote, "distinguish between the orders for the establishment of Christianity and Christianity itself." Close quote. It was these Christian convictions that led him to say, quote, "There is no liberty if the judiciary power be not separated from the legislative and executive." Close quote.
So this guy, Montesquieu, was huge
Yes.
on the separation of powers. He was huge on this idea because he got it from the Bible. I believe Montesquieu was probably looking at a verse like this in Isaiah 33, verse 22, which says, "For the Lord is our judge, the Lord is our king, lawgiver, the Lord is our king." Judge, judicial power.
Mm-hmm.
Lawgiver, legislative power. King, executive power.
Yes.
And the only being, by the way, those are only three ways political power can be manifested.
Mm-hmm.
And the only being that you would want to exercise all three simultaneously is something or someone with an uncorrupted nature, God himself.
Amen.
But as long as we're having governments of men over men, we've got to take those powers and separate them
Yes.
amongst the three branches of government.
Right.
So when the Supreme Court reaches back to 1964, a law that was duly passed, and rewrites it, they're usurping a legislative function.
Yes.
That's not what they're there for.
Amen. That's right.
I mean, if the Supreme Court wants to do that, step down from the bench, take your robes off, and run for office.
Exactly. Exactly.
So this is the situation in which we find ourselves, and this is why James Madison, in the Federalist Papers, which were designed to convince New Yorkers, farmers,
Yes.
published in the newspapers, to go ahead and adopt and accept and ratify the Constitution. This is why James Madison in Federalist Paper number 47 warned about the exact kind of problem that we're seeing today, where governors, executives want to be legislatures, judges want to be legislators. And what did Madison say about that? All the way back in 1788.
Yes, 1788. Quoting, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny."
So that's when tyranny commences.
Yes.
Tyranny, of course, is being governed by someone that's not accountable to you.
Right.
Tyranny starts when the separation of powers starts to get muddied. And that's exactly what we're seeing here with this decision, and what's what we're seeing with COVID-19 executive orders.
Yeah, yeah. And in a microcosm, you're seeing that also during this COVID-19 with these governors.
That's right.
Doing the things they're doing.
Exactly. And so we're at a real constitutional tipping point.
Yeah,
you
we
might
are.
say. Now, we have this article from Mark Sherman. It says, "Justices rule LGBT people protected from job discrimination," AP News. And it sort of describes the logic, if you will, of the courts as they took it upon themselves to rewrite the 1964 law, to include something the 1964 legislators weren't even thinking about.
Right.
And what does it say there?
All right.
Before we get into that, let's understand that the Supreme Court is not the first to do this. This comes from a pattern of lower courts doing the same thing.
Yeah.
And the Supreme Court just said, "Hey, this looks like a great idea."
Yeah.
And now we have a nationwide precedent because of it. Sorry to interrupt you.
No problem. The Federal Appeals Court in New York ruled in favor of a gay skydiving instructor who claimed he was fired because of his sexual orientation. The full Second U.S. Circuit Court of Appeals ruled 10-3 that it was abandoning its earlier holding that Title VII didn't cover sexual orientation because, quote, here it is, legal doctrine evolves, close
Whoa.
quote. Think about that. The court held that sexual orientation discrimination is motivated at least in part by sex and is thus a subset of sex discrimination, close quote.
So the lower courts, as this case was making, these three fact patterns were making their way to the United States Supreme Court. The lower courts got involved in this idea that, well, of course the 1964 law includes transgenderism and sexual orientation because, and this is right out of the Second U.S. Circuit Court of Appeals in a 10-3 decision.
Unbelievable.
Quote, legal doctrine evolves.
Unbelievable.
So humanity is evolving, I would say devolving.
Yeah. Yes.
And so the statute needs to evolve with humanity.
Yeah.
And who's going to evolve it upward? Not the people,
No.
not the representatives, but we as life-tenured, unelected, unaccountable people in robes that graduated from Harvard, we'll take the task upon ourselves to evolve the document upward. And I like what Russell Moore says. I'm not the biggest fan of Russell Moore, who is the president of the Ethics and Religious Liberty Commission. But in an article by Joy Pullman entitled "The Supreme Court of the United States Transgender Ruling Firebombs the Constitution," I like that title.
Yeah, that's a good title.
She quotes Russell Moore as follows. What does Russell Moore say?
Here's the quote. The precedents set here will have major implications. This will mean that legislators actually won't know what they are voting to pass because words might change cultural meaning dramatically between the time of passage and some future court case, close quote. And that's Russell Moore.
So if this mindset takes hold, and it looks like it is, a legislative body passes a law.
But not really.
Exactly. They don't know what they've actually voted on because some judicial panel down the road could take their language and read into it something they never intended in their prerogative, as they see it, to evolve the piece of legislation or the law upward. So legislators will never actually know what they're voting on to pass.
That's sort of the political equivalent of scripture twisting, isn't it?
Exactly. And I like the parallels you're drawing between what we use in terms of literal, grammatical, historical principles to understand the Bible versus these same principles that our whole nation was supposed to be founded on.
That's right. Yes, sir.
See, folks, when you get someone on the Supreme Court, you really don't want to know if they're Republican or Democrat, conservative or liberal. What you want to know is, are they originalists or not?
Yes.
I mean, they have to demonstrate a paper trail of going back to the writings of the Founding Fathers, ascertaining original intent, and applying that meaning to whatever matter it is they're contemplating and adjudicating at that specific time. Notice this article here from, let's see, Tyler O'Neill, entitled "Alito, Court's Preposterous Trans Ruling Threatens Religion, Speech, Privacy, and Safety." This article I like because it deals aggressively with the separation of powers issue.
In a powerful dissent joined by Justice Clarence Thomas, Justice Samuel Alito condemned the ruling as, quote, preposterous and betraying, quote, breathtaking arrogance. He didn't mince words here, does he? He noted that Congress has tried and repeatedly failed to amend Title VII of the Civil Rights Act of 1964 in just this fashion, and that no one interpreted the law this way until 2017. In this decision, as in Roe v. Wade and Obergefell and versus Hodges, the Supreme Court usurped the power of Congress by creating, quote, legislation, close quote.
So, gosh, if you don't like the way the Civil Rights Act of 1964 reads, well, then amend it.
Yeah.
That way we can get everybody involved in the discussion. And if the people don't like the direction the discussion is going, they can vote out their legislators or representatives in the next election cycle. Let's have some discussion. Let's have some debate. Let's have some hearings. And apparently they tried to, homosexual movement, transgender movement, tried a bunch of times
Yes,
to
exactly.
get it changed, and they failed. So what they didn't get accomplished through the legislative branch of government, they just got accomplished through the judicial branch of government with no hearings, no debates, no accountability.
And no real due process.
No due process. In fact, no one even interpreted the 1964 law that way until 2017.
Yeah.
So what is happening is the United States Supreme Court is legislating from the bench in contradiction to Federalist Paper number 47, and they've given us a ruling which is as bad as Roe versus Wade, abortion on demand, and more recently Obergefell versus Hodges 2015 decision where the Supreme Court invented out of wholesale cloth a constitutional right to same-sex marriage.
Repeat after me, tyranny.
Tyranny. And that's what Madison said.
That's what Madison said.
In Federalist Paper number 47. Notice this article here, continuing on with this separation of powers theme by Joy Pullman. We've cited this article before. Transgender ruling firebombs the Constitution. What does she say there?
Quoting, "There is only one word for what the court has done today. Legislation," writes Justice Samuel Alito in a dissent Justice Clarence Thomas joined. Quoting, "A more brazen abuse of our authority to interpret statutes is hard to recall," close quote.
I mean, the dissenters in the case said they're legislating from the bench. And call it what it is. Don't call it a Supreme Court opinion. Call it a piece of legislation.
Yeah.
And I like what Thomas says, in his dissent, a more brazen abuse of our authority to interpret statutes is hard to recall.
Wow.
You notice again this article from Tyler O'Neill, Scalia rolling over in his grave. Gorsuch leads a brute force attack on our constitutional system by PJ Media, or at pjmedia.com. What does that article say?
Carrie Severino also condemned the ruling. Quote, "Justice Scalia would be disappointed that his successor has bungled textualism so badly today for the sake of appealing to college campuses and editorial boards. This was not judging, this was legislating. A brute force attack on our constitutional system," she tweeted. Quoting, "Today, 6 judges acting as advocates opted to rewrite the statute themselves, short-circuited the legislative process, and in the process, denying the people a decision that should be theirs to make on a major issue," close quote. She also tweeted, have no doubts about what happened today. This was the hijacking of textualism. You can't redefine the meaning of words themselves and still be doing textualism. This is an ominous sign for anyone concerned about the future of representative democracy, close quote.
I might quibble with her language. We're not a democracy or a republic.
Republic,
but,
yes.
You know, we get the idea. It's your legislative representatives that are accountable to you. And when you shift that authority over to the Supreme Court, not only are they legislating from the bench, but as an unelected group, that, by the way, only needs 5 votes to get something passed. The whole concept of representative government, is flipped on its head. These articles continue. We have this article from Calvin Freiberger. U.S. Supreme Court votes 6-3 to redefine sex and write transgenderism into a 1964 law. What does he say there?
the majority's reasoning flies in the face of both the plain statutory meaning of sex in 1964 and the clear legislative intent of the lawmakers who drafted and passed the Civil Rights Act, as explained by Alliance Defending Freedom Senior Counsel John Bursch, quoting, "There is little dispute that in 1964 the term sex was publicly understood, as it is now, to mean biological sex, that is, male and female," close quote. He writes, quoting, "After all, the term gender identity wasn't even part of the American lexicon at the time. It was first used, or its first use rather, was at a European medical conference in 1963, and no semblance of it appeared in federal law until 1990, close quote."
So no one ever confused gender in the 1964 civil rights sense with transgenderism until 1990 in federal law. And this whole idea wasn't even introduced until a medical conference.
Right. In Europe.
In Europe in 1963. Now, the article goes on and it quotes Brett Kavanaugh, one of the dissents, who sort of applauds the same-sex movement for their grit and their hard work and their tenacity. So he's kind of trying to throw a few flowers their direction.
I think so, yeah.
But then he correctly says, my concern about the court's transgression of the Constitution's separation of powers. Who decides?
Yeah.
That's the great issue.
There it is.
This should be part of the legislative process, not for this court. It was Congress's role, not the role of this court, to amend Title VII of the Civil Rights Act of 1964.
He's right.
Because when you usurp the legislative process, you usurp all of the tools that they use to analyze data, hearings, expert witnesses. I mean, all of that is gone. And it's decided by 5, in this case 6 people that aren't accountable to the electorate.
Very scary.
And this is why we need to be aware of this issue, and this is why we keep losing the culture war.
Yeah.
Because we keep showing up at the hearings, and we keep wondering why things remain the same or things don't change, and the answer is we're being usurped.
That's exactly right.
The ground is being cut out from under us, you know, consistently and routinely. Now, there's something called the Equality Act that they want to pass. Tell us about that. It's that last paragraph there.
Today's ruling also largely relieves congressional Democrats, well, we want to do that, of the need to enact the so-called Equality Act, a bill that would legislatively impose the same requirements on the country, though some of the details and specific applications may vary, meaning some LGBT activists will likely still demand that the act be passed to codify today's ruling.
So they've been trying to do this very thing through what's called the Equality Act, and they've been unsuccessful. So instead of saying, well, let's morph our arguments or sharpen our arguments, what they do is they decide to usurp the legislative function entirely and to get it passed through the judiciary. So the Equality Act, as much as everybody was upset about that and up in arms about it, because you know what that act would have done? It would have brought men who at that moment felt like women into female sports, where your daughter or your granddaughter is competing against a male physical body. And you know what could happen to her? She could get hurt if it's a contact sport. So that's what the Equality Act was trying to accomplish. Well, guess what? They got it accomplished anyway.
They got it anyway.
Thanks to this latest Supreme Court decision. We notice here from an article from AP News that number of efforts by Congress were made to change the law so far. In fact, we've got this article here from DailySignal.com.
They failed. Those efforts failed.
Yeah, go ahead. Efforts by Congress to change the law were tried but failed.
So we're doing our part down here at the lower levels.
That's right.
But the court decides, well, I don't care what you think.
That's right. And then we have this article from Daily Signal where it says Alito recalled that there have been numerous bills introduced in Congress over the last 45 years to amend the law, the 1964 law, and add those terms, but they all failed. So what they haven't been able to do, what they've were unsuccessful in at the legislative level, they got accomplished in the judicial branch of government. That's tyrannical, is it not?
There's no other word for it.
Yeah. So what does it say here? Back to our article here from Pullman. The Supreme Court of the United States transgender ruling firebombs the Constitution. What does that say there, that excerpt?
Yeah. Courts are not supposed to legislate because citizens cannot consent to legislation imposed by courts and have no direct means for altering Supreme Court decisions like we can alter laws through our elected representatives. This is the real issue, folks.
This is the issue here.
When courts legislate, they disenfranchise the people. They invalidate our votes, our God-given natural right to rule ourselves. By adding words to statute that Congress did not put there, and they do this and has repeatedly and explicitly refused to add, these judges are destroying our Constitution, our way of life, the people's sovereignty, and thus our human dignity.
So you federalize an issue, the Supreme Court rewrites a statute, and what's turned on its head? The whole premise of the United States,
yes,
which is governing by the consent of the governed. And a government by the people and for the people, as Abraham Lincoln said, we the people, by the people, for the people, shall never perish from the earth. I mean, the whole concept of we the people is gone.
That's right.
Because now the most important issues in our society are not being decided by the correct branch of government. They're not being decided by our elected representatives. They're being decided by the unelected Supreme Court.
Well, we the people has just been given a new definition. It's 9 people sitting on a court.
And actually, if I can amend that statement, it's 5.
5 people, excuse me.
Because you only need
you only need a majority, right?
5 for a majority opinion.
Yeah.
So there's a big debate in our society. Are we going to, take existing civil rights law and keep it or expand it? Now, my perspective is keep it as it is, because to gain civil rights status, whether as a female or as a black person, Hispanic person, Asian, whatever, you have to demonstrate 4 characteristics. You represent a sizable group. You have a characteristic about yourself that's not based on behavior, like skin color. You have been discriminated against because of that. I think women can demonstrate that in American history.
Yes.
African Americans can demonstrate that in American history. And then you have to also be able to demonstrate that your immutable characteristic is what is called innocuous, doesn't harm anybody. And if people will go back to Pastor's point of view number 40, we demonstrate that the transgender movement, the gender fluidity movement, the same-sex movement can't demonstrate any of those 4 characteristics.
Right.
So that's what the discussion is about, and the debate is about concerning whether to expand those civil rights categories. So if you want to have the discussion, let's have it.
Exactly.
Well, now we can't even have the discussion anymore because the court stepped in and resolved the issue for us. And so it's interesting that in the Federalist Papers, Alexander Hamilton called the judicial branch of government the least dangerous branch. And that's why our founding fathers were comfortable appointing people to the Supreme Court for life, because they never thought they would wield the type of power that they have today.
Wow.
And what's happened is the least dangerous branch of government has become the most dangerous branch of government. Now, Thomas Jefferson, in a private letter that he wrote, saw this trend coming one day. And what does he say here? Slide number 12.
Quoting, this is from the writings of Thomas Jefferson. You seem to consider judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy.
Of a what?
Oligarchy.
Okay.
Our judges are as honest as other men, and not more so, and their power the more dangerous as they are in office for life, and not responsible as the other functionaries are to the elective control. The Constitution has erected no such single tribunal. Close
Now,
quote.
people say, well, why do you keep quoting these writings of the Founding Fathers? The reason we keep quoting them is because they are the plumb line.
Yes. Yes.
Now, the book of Amos, chapter 7, verses 7 and 8 talks about a plumb line.
Yes.
And what do those verses say?
All right, Amos, reading from the New American Standard 95 Update, Amos chapter 7, verses 7 and 8. Thus he showed me, and behold, the Lord was standing by a vertical wall with a plumb line in his hand. The Lord said to me, What do you see, Amos? And I said, A plumb line. Then the Lord said, Behold, I am about to put a plumb line in the midst of my people Israel. I will spare them no longer.
See, a plumb line is a line that's weighted a particular way, so it's always straight.
Right.
So you hold up a building structure next to the plumb line's not going to lie to you.
Right.
And you can ascertain whether the building is crooked or not crooked.
Exactly.
That's the writings of the Founding Fathers.
That's exactly right.
That's how you know things are going awry in our society. When you look at the writings of the Founding Fathers, you look at their warnings against merging the separation of powers.
Mm-hmm.
You look at what they said in Federalist Paper number 78, that the judicial branch of government is the least dangerous branch. And you look at things like what Thomas Jefferson was writing about in his personal writings about not letting judges resolve all of your issues for you.
Yeah.
Because if you do that, you'll be under an oligarchy.
That's what he says.
Now, you've studied Greek. You know what the Greek word oligos means. It means few.
Mm-hmm.
So an oligarchy is essentially a situation where you're being ruled by a very small number of people.
Right.
And that's exactly what just happened to us on Monday.
Yeah. Yeah.
I mean, one of the most controversial issues of our time related to expanding civil rights to people that don't meet the initial criteria of sizability, immutability, a pattern of discrimination against them, and an innocuous characteristic. That just got resolved in a way I don't personally like.
Yeah.
By a life-tenured, unelected, 5-member committee.
Right.
Now, if that's not the definition of oligarchy, I don't know what is. Speaking of plumb line, notice this quote here from George Washington, America's first president.
All right. Quoting, if in the opinion of the people, the distribution or modification of the constitutional powers be at any particular wrong, let it be corrected by an amendment the way the Constitution designates. But let there be no change by usurpation. Though this may in one instance be the instrument of good, it is the customary weapon by which free governments are destroyed. Close quote.
See, when you talk like this, people will say, well, wait a minute, hasn't the Supreme Court done some good? And it's true, they have. For example, it was the Supreme Court that overruled in a case called Brown versus Board of Education. They overruled Plessy versus Ferguson, which was the separate but equal doctrine. And they desegregated the public schools. And so people say they did something good. So therefore trust them with this power.
Yeah.
But you need to look at the plumb line of the writings of George Washington. George Washington warned about this.
Yeah.
He said, look, they might do good in one instance.
Right.
But if you give them the power to do good, what have you given them the power to also do?
Do evil.
To do evil. And he says this is the customary weapon
Yeah.
by which free governments are destroyed.
Yeah.
See, the plumb line of truth is there. And I don't think we're paying attention to what he's saying.
Well, people don't know what he said. That's what the problem is.
Therein lies the problem.
Yeah.
So what do people believe today? They believe what William Douglas quipped during the Warren Court years. The Warren Court years is where this whole thing really got out of hand. He said, quote, "With 5 votes, we can do anything."
He was right.
He was right. See, you give people this kind of power, yeah, they might desegregate the schools, but you know what else they can do with that power? They can start creating abortion on demand, Roe versus Wade.
Mm-hmm.
You can't pass laws anymore stopping abortion because we've just federalized the issue.
Yep.
They can also take Bible reading and prayer, which was a 200-year practice in the United States prior to 1963, and sweep it completely out and put in its place humanism and Islam.
Yes.
And that's what's happened in our country.
Yep.
So it's the customary weapon by which free republics are destroyed. With 5 votes, we can do anything. And really this whole discussion relates to what is called the scope of judicial review. Judicial review is the awesome power that the United States Supreme Court has to take acts of a legislature and render them unconstitutional. Now, most people believe that the court legitimately has that power going back to a case called Marbury versus Madison, 1803. And then the Supreme Court continued, by the way, all under Chief Justice John Marshall, our 3rd Chief Justice to the United States Supreme Court. Interestingly enough, I was named after him because my father was studying for law school at the time, and he was reading all of these books about Chief Justice John Marshall, so he gave me that as my middle name. My middle name is Andrew Marshall Woods. And so, for whatever reason, I know an awful lot about Chief Justice John Marshall. And he had a lot of good things to do and say, but also he expanded the Supreme Court beyond what the Founding Fathers intended. So he came up with a ruling in McCullough versus Maryland, 1819, where he basically said that it's okay to have a national bank. Well, the problem is you go back to the text of the United States Constitution, it doesn't give the federal government that power. And he said, well, if the power to coin money is there, and if the power to tax is there, then obviously our Founding Fathers intended for them to have a bank. And so what you have is judicial review, the power to render ordinary acts of the legislature null and void if they violate the Constitution. I mean, that's part of the American system, thanks to Marbury versus Madison. The question is, how is that power going to be used? And there's 2 completely different schools of thought on it. Some people, like ourselves, say you use it very selectively and use it very narrowly only if the original intent of the Constitution is being violated. Then you exercise judicial review. But the left says, no, you use it as much as possible to pursue policy goals and ends that could not get accomplished at the ballot box. And so that's what this whole discussion is about. And what you have today on the United States Supreme Court are 3 justices only that believe in limited use of judicial review. 6 of them believe in an expansionistic use of it.
Wow.
And so that's our whole discussion of the separation of powers. Now, we've already gone, Brother Jim, an hour and 13 minutes on this, and we have 2 more categories that we want to talk about. So we're going to do this.
We're going to
take a 15-minute break, and then we're going to come back and we're going to complete Roman numeral 6 and 7. So we've talked about other cases denied, the facts, the ruling, the dissent, the separation of powers issue. We'll be back in 15 minutes to talk about number 6.
All right.
We'll see you then.
Sounds good.